All right. Hello, everybody, and welcome back to Raw Law Unfiltered with the DUI Guy Plus. That's me. Thank you all for everyone who joined me yesterday and have said kind words about my review of Ben's filing yesterday. I mean, I wish I could say, like, it was planned and orchestrated for me to be like that. No, I literally was telling you all how I felt, what I felt about it, why I liked it, and it really got me going. It really got me going. It got me excited. It got me fired up. Why? Because quality work. I'm a professional attorney. And as a professional, we see a lot of junk. We see prosecutors slacking. We see judges doing the wrong things and making the wrong calls and bad law being created. So when you have the opportunity to see a masterful piece, it's like an orchestra in New York, like the creme de la creme. When you get to see something like that, it just gets you going. It just makes you feel fire. It makes you feel good. It makes you excited when it's concise, direct, to the point, with no flab, meat only, no fat. It simply is just, it's inexplicable. I mean, you saw me yesterday. You saw me yesterday. So you know that it was just how I felt about it, because it was just so beautifully written and so to the point, and goes to the heart of the issue. It goes to the heart of the issue. Notice how there were several arguments that were made, but the primary one, and this is what we're going to cover today, is the amici response to Ben's motion. Okay, and I would like to apologize. Yesterday, I was a little too excited. I got a little overly loud at certain points, so I put the microphone a little bit further away from me. I am not going to be leaning into it and screaming like this. I promise. It's just something that I need to practice. So hopefully, if I get loud, maybe I can like move myself away from the mic, so I'm not like scaring your kids and your fur babies, and your eardrums are going to be intact. So. I really, really, really think that you all are going to enjoy this, because it just doesn't get better than this, folks. It just doesn't get better than this. Okay, so we got to start at the beginning, right? We got to start at the beginning of this whole mess of filings. So the amici people, or as some people like to call them, the amica cream people, have filed their briefs. This happened on November 23rd, 2022, the day before Thanksgiving. It was in the same day that Amber's brief was filed, which we read on that Monday when Laura B. so graciously obtained a copy and sent it to me earlier this week. Or was it last week? I don't know. I'm completely losing track of like all of my days and weeks now. They all start blending together, so I apologize. I probably got it wrong. But anyway, here's the important part. We had Johnny's response to Amber and Amber's response to Johnny. Like it's all a cluster, If you follow my videos, these are everything is on point. We're not missing anything. This is what we read yesterday. We're going to touch on that just for a moment to clarify why I'm talking about it and how it ties into today. Remember the first and main argument of Ben Chu, right? This is Ben Chu's. Come on. Sorry, it's not loading. It looks like it's crashing. I am so sorry. Technical difficulties. How about if I make it full? Seriously? Okay. Well, that's not cool. I did not expect that. Give me just a moment. Let me see if I can load up another copy. Oh, I know why. I know why this is happening. Okay. Give me just a moment, everybody. Okay. That should fix it. So Ben's response. So they filed the Amici briefs on November 23rd. Let's refresh it. The Amici briefs have been submitted, and they're basically asking the court to read them, right? Ben is saying, look, we're not interested in having your briefs. You're getting in the way. You have absolutely nothing of value. But most importantly, and this is something that you cannot anticipate as an attorney up until the moment it is actually filed, is, hey, there's nothing over there for you. She's trying to like dig under the carpet. I'm like, there's nothing there. There's just going to be more carpet. Right, Zinni? She's so adorable. The filing has errors. This is something that you cannot anticipate. This is something that you cannot anticipate as an attorney in the middle of litigation in the Court of Appeals. When filings come, you read them, you assess them, and you look for ways to attack, because you never want to be on the back foot. The Amici people are now on their back foot. I'm sure Dr. Proudman is not so very proud of her work at this moment. And I don't say this lightly. And you're about to see why that is. Because there is a very serious defect in this filing that they have made. The two filings, both of them, that they have made. And they are potentially going to destroy the court's desire, legally speaking, from reading the brief. So here it is. A brief amicus curiae must comply with the rules, obviously. But which rules must it comply with? It must comply with the rules applicable to the brief of the party supported. Remember, we read that yesterday. Because the Amici are seeking to support Ms. Heard's opening brief on her appeal, they are required to comply with all the requirements set forth in Rule 5A20, including the requirement under Rule 5A20C that the brief must contain a separate heading for assignment of error. This is what we read yesterday. So I broke it down. First, we're going to look at the rules of court, which I just tweeted about. So if you want the TLDR digest version, it's on my Twitter. But we're going to break it apart, and I'll explain piece by piece what all this means and what has been trying to say that they failed to do. Because it's very concise. It's very direct. And remember, courts of appeals are usually going to opt in for the road less traveled, for the path of least resistance. They don't like to take the machete and go through the jungle. If there's a path that's already carved, that's easy, you could just tip, 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 tip. That's what the court is going to do 10 times out of 10. All right. So the rules of court. First and foremost, what is the rule? This is rules of the Supreme Court of Virginia, which we're going to be looking at. I'm going to read this heading once, but it's going to apply throughout. Part 5A, the Court of Appeals, procedures following perfection of an appeal. And this is particularly Rule 5A:23 that relates to amicus curiae briefs. Basically, remember we talked about this. Courts of appeals are courts of rules. When you're in the trial level in circuit court and district court, there's a lot of verbal battle going around, objections to evidence coming in and da da da. On the Court of Appeals, it's a lot simpler. The record is already made and the rules are literally written down. All you have to do is open them and read them and comply with them. And if you fail to comply, we'll see what happens. So the brief amicus curiae may be filed at the petition, appeal, and rehearing stages, depending on certain guidelines, which do not really matter here. But this one does matter. This is the one I highlighted. This is C. A brief amicus curiae must comply with the rules applicable to the brief of the parties supported. So what does that mean? Very simply, if you are filing on behalf of the appellant, you follow the rules of the appellant. If you are following on behalf of the appellee, you must follow the rules of the appellee. Boom. Easy. Next. What are the rules of the appellant? Because Amber is the appellant in her own appeal, because she's the one appealing, and that's where the amicus curiae filed their briefs. They didn't file it in Johnny's appeal. They filed it in Amber's appeal. This is what it says. Under a heading entitled Assignments of Error, this is what Ben Chu pointed the finger at. Under a heading entitled Assignments of Error, the brief must list clearly and concisely, without extraneous argument, okay, no fluff, just clearly, concisely, the specific errors in the rulings below or the issues on which the tribunal or court appealed from failed to rule on, upon which the party intends to rely, or the specific existing case law that should be overturned, extended, modified, reversed, etc. The exact reference to the pages of the transcript, written statements of record, of facts, record, or appendix where the alleged error has been preserved. Preservation. Remember, Court of Appeals will not look at anything new. I remember 6 months ago, people had, well, when they appeal, are they going to bring in all this new stuff? No, they cannot bring in new stuff. Only old stuff can come in. There it is. That's in the rule. Must be preserved. Preserved. There's that word. In the trial court or other tribunal from which the appeal is taken must be included with each assignment of error, but is not part of the assignment of error. If the error relates to failure of the tribunal or court below to rule on any issue, error must be assigned to such failure to rule, providing an exact reference to the pages of the transcript. The pages show us where it is. Written statements of fact, record, or appendix where the alleged error has been preserved in the tribunal below, and specifying the opportunity that was provided to the tribunal or court to rule on the issues. Wow. That was basically a long-winded way of saying, point to where it's preserved. And that's the rule of the appellant, right? That's the rule of the appellant. But we're talking about the amicus curiae, Larry. Are you blind? Do you not know how to read? It says appellant. It doesn't say amicus curiae. But don't forget Rule 5A23, which we just covered, that they must comply with the rules applicable to the brief of the party supported. Remember? So this rule in 5A20 is extrapolated onto the amicus curiae because of Rule 5A23. Damn it, Larry. You're not so blind. Penalties for non-compliance. And before we get to that, there is another, very, very briefly, I just want to show you, because there are two places where the penalties are written. The effect of a failure to assign error. What is the court going to do if you fail to do your job? Effect of failure to assign error. This is what the court says. This is a big paragraph that we just read. If you fail to do this, if you fail to show us where it is to be found, this is what we're going to do. Only assignments of error listed in the brief will be noticed by this court. Why is that important? Again, you can't just bring in extraneous stuff and be like, well, look, we failed to preserve it, but we really, 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 really want you to look at this. The court's going to be like, no, I'm sorry. Too bad, so sad, sucker. There's the door. Appeal dismissed, or argument will not be visited. Argument will not be reviewed. Argument will not be decided upon. Only assignments of error listed in the brief will be noticed by this court. And this is the most critical piece right here. This is Ben Chu's entire first argument that he made that we went over yesterday. If the brief does not contain assignments of error at all, the brief will be dismissed. Not might, not may. We may entertain the possibility of it's a shall, it's a will. You fuck up without curing it, we will dismiss it. Now, they fucked up. They did not include it in there. There was no assignment of error citations to the record. But what did they do 2 days ago? This is what they've done. They filed a precipe. What does that mean? This is a oops, we fucked up motion, and we're trying to cure the record for what it's worth. This is an admission to the court saying, we fucked up. We're so sorry. Please forgive us. We will try to cure it as best we can. And please allow us to continue to move forward unabated. Okay. Chibi Peach says, I just got in and here you're almost savage as you read through, not minding the passion at all, by the way. Thank you, brother. Thank you, Chibi Peach. And I saw another one. Nicholas is here. Calling C. Boozy as an expert in online hate is like calling Harvey Weinstein an expert on sexual harassment. Technically true, but not the way you'd want it. Are you in the right stream, Nicholas? Are you? Did you like watch another one of my videos? Because this is definitely not what we're talking about today. But hey, I please keep them coming. I'm like, see Boozy, where'd he come from? I thought we were talking about Ben today and the Amici. But hey, I'm not discriminating. Please participate as much as you wish. So, Amicus Curiae, they're writing this, and I tweeted a portion of this document. It's not very lengthy, but it has a few pieces and a few parts that you have not seen yet. The Amicus Curiae, in support of appellant Amber Heard and reversal of the judgment, hereby file this supplement to its corrected brief. Now, this is language that you never want to find yourself filing, especially in the Court of Appeals, especially when rules are everything, especially when dismissal for failure to follow the rules is on the table, especially when you're an outside party making mistakes, especially when you have nothing new to bring to the table, especially when it's a pure PR move, and especially when you make laud statements as undisputed statements of fact, which is complete nonsense in an appeal brief. Judges dislike that with a passion. So you have like this stack of bad idea, and you fuck up on top of everything. Like, there is no worse position you can find yourself in, basically, as an amicus curiae to any party. Appellant, appellee, doesn't matter. Remember, they're an outsider coming in saying, we have something to offer. And the court says, okay, what do you have? And then, you know, the other party goes, wait a minute, court, wait a minute. They messed up. And the court's going to be like, really? Interesting. Let me take a look at that. Maybe I'm not even going to entertain what you have to offer at all, especially if you can't follow basic rules that are written that I have access to, that you have access to, that everybody has access to. They're public rules. They're not some mystery gem you have to seek out and call a bunch of clerks at the Supreme Court and maybe get a copy of the document. It is public for a reason, so that anybody filing appeals can follow the rules, so that the court doesn't have to sift through 10 different styled documents. It's cringe. It's absolutely cringe. Amicus Curiae in support of Amber Heard and reversal of the judgment hereby file a supplement to correct our mistake. That's literally how it's read. Although amici do not believe that assignments of error are required for an amicus brief. What? Okay, that's basically a flat-out admission. Look, we didn't read the rules, and we don't really care. That's what that says. That's what that sentence literally says to a judge. Yeah, you have a file. Like, we understand that some DUI bozo on the internet just went through how the rules apply and read it to the public. And sure, they exist, but we don't like rules. We're kind of like Amber. We're rule breakers. We're rule violators. That's literally what that says. Although amici do not believe in rules, we provide information as to which its arguments apply to specific assignments of error identified by appellant Amber Heard to assist the court in its review of the case. So despite the fact that we don't believe in these fucking rules, you know what? Just to be on the safe side, since you asked so nicely, Mr. Chu, we are going to include them. You know what? By God, you have convinced us. I am so sorry. Such a knucklehead. Like, what? It's unbelievable. It's unbelievable. This is, again, especially amicus curiae goes without saying, but you never, as a filer in a court of appeals, ever want to be put in this position where you have to file something like this. It's embarrassing to you, it's embarrassing to the process, and you're embarrassing yourself before the court. Do you have time to check the 12 font issue yet? I did not. And I'm not going to, because they didn't respond to it. They didn't respond to it, and I'm going to take it at face value, me, myself, and Mandy. But that's a great question. I mean, we can. I'm not going to say no to it, but like, it's literally that is that is like the most blatant dumbass violation I've ever heard of. I'll just have to do a Control F search for font, literally, and we can do it right on stream here. Let me go through this first. I know, thought of it yesterday and couldn't wait. Okay, Nicholas, you're all good, brother, dude. Keep on keeping on. I fucking love you, man. Thank you for all the participation. I think you're a lawyer in not Switzerland, not Holland. Some northwestern European country, Denmark. I forget. Sorry. I think you told me before and I forgot. Saskatchewan, anyway, not Saskatchewan. What am I saying? Anyway, is the font better today? Unjustified paragraphs got me through our brothers. Yes, font is better today, I think. Okay, Sweden. Is it Sweden? It is Sweden, isn't it? All right. So now they're on the back foot. Ben Chu attacked, and they responded. What did they respond with? Exhibit A provides a revised table of contents for the argument section of the brief, that reflects the assignment of error relevant to each section of the amicus brief. Let's look at it. The argument table for the contents with assignments, right? Table of contents. We have a new TOC. It's just one pager. It's just one page. They're like, okay, you want us to include the assignments? Yeah, no problem. You got it, brother. You got it. Assignment 3. This one, assignment 14. This one 3 and 13. This one is 12, 9, 10, 16, and 2. Okay, you happy? Are we Gucci court? Exhibit B then also identifies each assignment of error identified by the appellant, the section of the amicus brief that discusses that assignment, the pages on which that discussion can be found, and the record cites for the preservation of error of each assignment of error addressed by the amici. There they are. This is Exhibit B. Assignments of error, the one we just mentioned, 2, 3, 9, 10, 12, 13, 14, and 16. The arguments section, where it is found in the brief, the page number, and where it's preserved in the record. You want it, court? You got it. Oopsie, so sorry. We made a mistake. Here is our correction. Respectfully submitted. And we only have one lawyer here. Counsel for the Amicus Curiae, Thomas Urban from Fletcher, Heald, and Hildreth. He's the pawn. Remember, he's the pawn that is licensed in Virginia. So like all the amici, most of them, at least on one of the briefs, basically piled onto him, and they filed their pro ac vici, the let us practice in this court, please, motions. And he's the one licensed there. So they have their man on the ground. And of course, the certificate, as always, Rottenborn, Chu, and Ward Brown are all listed. Short, sweet, to the point, but lacking in so much, because all they addressed is the absolute most crucial one. Because if they hadn't responded to this, honestly, the appeal, the brief would have been chucked, not even a question, because of this rule that we just read. Remember? Effect of the failure to assign error. If the brief does not contain assignments of error, the appeal will be dismissed. Period. The end. Go home. So they're like, well, shit. We got to include that. Welcome as a new member, David G. And Retired Nana says, when you check on the font, can you check if Amber's appeal was in the right font size? If it isn't, will she be able to file a supplemental? I don't know that. I don't think it has been alleged yet. If it will be alleged in the motion. I as much as I would love to work with, I was going to say Ballard Spar, not Ballard Spar. The love of Benji. Brown Rudnick. As much as I would love to work with Brown Rudnick, I don't work with them. So, I mean, we'll when we read the response, we'll know everything. You know what I mean? We'll figure things out. There's no need to put the cart before the horse. It's a great idea, but you know, it's not that easy sometimes. I mean, just checking the font, I suppose. But let's look at the rules. Let's look at the rules of court. Why is it not showing? Let's see. Let me close these, open it up anew. Here we go. All right. Let's see if we can find it. Documents, formatting, line spacing, font. Specific rules for motions, petitions, and briefs. Except by leave of court, all motions, petitions, and briefs, including footnotes, must use one of the font styles listed on the court's website in at least 14-point type. There you go. There's your answer. Just realized it's tiny. There it is. 14-point font is a must. Does that answer your question? Welcome, Sydney, as a new member. Don't forget to like this video, comment below, subscribe to the channel if you haven't already. There it is. No, like I said, Raul, The precipice is not a savior. It is a plea for mercy. It is a plea for please don't axe us. And when I don't mean, you know, I'm talking like AXE. Please don't like chop our heads off with an axe and not read our briefs. That's literally, remember I said that's not a position you want to be in. That's exactly why. Because you're pleading with the court, like, please don't kill us. We're sorry we made a mistake. We're trying to correct it. Here it is. We're correcting it. Please don't kill us. So, yeah. There you go. There's the font. Got to be 14-point type, and it's printed on the court's website, the types of fonts that are permitted. Now, actually, I have the appellee brief right here. Let's see if it was, I think it was, that looks like 14-point font. That looks like 14-point font. What do y'all think? Yeah, I'd say so. I'd say so. I just find it extraordinary that these lawyers can't get their shit together, especially when they're butting into a brief where nobody asked them to butt in. They are doing it out of their own goodwill, right? As we now have learned, it doesn't look like that's entirely true. It looks like they have been in cahoots with Amber, because how else did they get access to all her arguments, and cited them in their brief, echoed the factual bases, as Ben Chu so audibly mentioned yesterday. You know, it's just, and the saddest part of it all, they know it's public. They know all of these filings are public. None of this is like done under seal. So all of this dirty laundry is literally up for grabs. Is literally, I mean, this is what I've been doing. When I ask for stuff, I'm not like magically creating documents. I am simply obtaining what's already in the record. And when you're filing garbage into the record, I don't know what you're expecting. I really don't. I don't understand. Even as a PR move, you have now completely, you've taken a shotgun and you pointed it at your faces and you pulled the trigger. This is literally your PR move right now, because you have embarrassed yourselves to the utmost maximum capacity. You violated the simplest of rules. You failed to include, it was just an assignments of error. Oh, big whoop-de fucking do, right? No, wrong. If you're just joining us, go to the beginning of the video. You'll see why. The court does not forgive. The court does not excuse. Rules are there to be followed. You are not an exception to the rules. And if you fail to follow the rules, there will be consequences such as dismissal, potentially, of your amicus briefs. Now, the court has not yet ruled on it. It may rule on it any day. So Ben filed his objection to the amicus briefs. Well, let me go back. So just to explain the timeline, let's leave Johnny's appeal aside for just a moment, and let's talk about the timeline. What has happened and what is going to be happening, right? Thank you, Claire Nunes. If I can click on it. Thank you. There we go. So here's what's going to be happening. What has already happened, right? Amber filed her opening brief with 2 amicus curiae, which collectively, if you go by the 14-point font, you are looking at 100 pages. Oh, excuse me, 150 pages of stuff, right? The 2 amicus curiae briefs and then Amber's brief. So you have 3 pieces that have been filed on behalf of Amber. Those 3 pieces, the 150 pages, now Ben Chu said, you guys, this is insanity. They're violating the rules. They're bringing extraneous stuff that has absolutely nothing to do with the appeal. Court, make this make sense. Because now we have to respond in 5 pages. We have to respond to all this junk. 150 pages worth of stuff. We only get 1/3 of that. And we're not going to ask the court for a 100-page extension to respond to all of that because the court will never agree to that because the court is not insane. So, and they responded on Tuesday. This is happening literally in real time, Monday, Tuesday. So Ben filed that on Monday. On Tuesday, they responded with what we just went over. Oops, my bad, sorry. Here it is. And like, it's like a spray and pray. It's like a here you go and all right, let's see what happens. Literally, like holding them by the back of their, like, you know, slapping the neck like, shit, oh God, this is not good, this is not good, this is not good. That's where they are right now. The court in the interim, so right now Johnny is writing his response to Amber's brief. Not Johnny literally, but his team, right? Ben Chu, Camille Vasquez, and all of them, and Brown Rudnick. So as they're drafting the response, and they have 30 days on this to ask for an extension, which they already preemptively asked, and Amber's team did not object, but the court was like, we're going to hold off on that. If you remember that, that was about a month ago. But they may now refile and request an extension, so it may or may not be due December 23rd, because we're about 2 weeks away from that. And the court now has to respond to this intermediate motion by Ben saying this Amici Curiae shit needs to fuck off. You need to scrap this, and here's why, which is what we read yesterday. They responded with oopsie daisy, which we just read and went over, and included what they missed out on. And now the court needs to say yay or nay, I suppose. That would be the only logical move because Johnny has to respond to the brief, the initial brief. And he can't respond to it because he's got 150 pages of garbage to respond to. So if the court, let's say today, tomorrow, Monday, Tuesday, whatever, says, look, the amicus curiae have nothing to offer. They're unintelligible. We're uninterested. They don't bring anything new to the table. We're not going to entertain them. Please just respond to the opening brief by Amber Heard. For example, this is a very real possibility at this juncture. Then Ben Chu and the team will write their response, maybe ask for an extension. I know that they're working on it. Literally, as we're talking, as I'm doing this live, they're working on that brief. I know that for a fact. Why? Because the clock's ticking. And the clock's ticking, lawyers work. So that's what they're doing right now. Now, with that being said, once the court rules, they may or may not ask for an extension because the court in theory could rule like, look, the amicus brief, like this one is defective, so we're going to chuck it. This one's not defective, so we're going to keep it. It's possible. Anything's possible. Or they'll say they've cured the error. It's harmless error. We'll include both. And then instruct the appellee, Johnny Depp, as to how to respond to it. Does that make sense? I mean, that's really it. That's the whole timeline. That's how it's going to work. And so once the once the court issues an order based on everything that is happening this week, so this order should be forthcoming within days, because otherwise the appellee doesn't know what its next move is. Literally, do I respond to the appellant brief? Do I respond to appellant plus one amicus curiae? Do I respond to appellant and two amicus curiae? Like, do I have an extension of time? Do I have an extension of pages? Do I have an extension of anything? You know, so many questions. We do not yet have answers, but they're coming. The Court of Appeals is going to rule as to what they're going to do. So we have that to look forward to. I thank you all for joining me. I'm going to pop into Popcorn Planet. He invited me and he sent me a link. So go ahead and check me out there. Nick will not be coming tonight. So this is the live for today. Tomorrow we're doing Boozy and Spoutable. And then Saturday, maybe I'm trying to move Nick to Saturday. He'll let me know.